Hey, welcome to today's video. I'm Richard Chapo. I'm a privacy lawyer in San Diego, California. Today we're talking about a court ruling coming out of the EU dealing with cookie notices, specifically pre-check cookie notices. So the case involves a company called Planet 49, and they run online gambling and lottery type contests, which in the EU gambling laws are much more business friendly than they are in the U.S. So while you wouldn't see any of this in the U.S., it's perfectly legal to some extent in the EU. And so they were running, I believe it was a lottery in this specific case, and they were seeking consent from participants for two things. One was the right to send that participant marketing and promotional materials, and the second thing was the right to place cookies on the participant's electronic device, first and third party cookies, so they could help them log in and collect data on those people and what have you. Now they had a box in front of each one of these consent statements, and the basic idea was a person had to check the box to give their consent. Kind of what you see, on a lot of sites these days. Now, the thing that came up was that for the cookie text, Planet 49 had pre-checked the box. So by default, a participant was giving Planet 49 the right to put cookies on their electronic device. The question was, well, is that a valid approach? Is that valid consent? And the court ruled, to the surprise of nobody, no, Nein, it is not. And the reason for that is there's no affirmative act by the participant in the lottery showing that they have actually given their consent. You can think about it in an offline situation to get kind of an idea of how strange the approach is. Let's say that you decide you need privacy work, you want to comply with the GDPR or the California Consumer Privacy Act or whatever, and you retain me. I'm going to send you a retainer agreement. And the way this traditionally works is you'll read the retainer agreement, asking questions you have. If you don't have any, you will then sign the retainer agreement. You'll send it back to me. I'll sign it. And we have a contract with two signatures on it. Well, now imagine if we took the approach that Planet 49 did with this contract. What would happen is I would prepare the retainer agreement. I would sign on my behalf. I would then sign it on your behalf. And I would tell you, oh, hey, we have a written agreement and here's a link, if you ever want to read it, but let's just get started with your stuff. Pretty good chance you won't have any idea, what's in the retainer agreement, the fact that, you've assigned your 401k to me, those kinds of little pilfering details. And it would cause chaos. We would have complete and utter chaos. And so the decision in this case is getting a lot of notice. I'm not really sure why. It's a pretty basic decision in my mind. But the rule that kind of comes out of this that companies, large and small, should keep in mind is that if you're trying to get consent from somebody for something and you're going to use the check the box approach, well, you cannot pre-check the box. When you pre-check it, you invalidate the whole process. It becomes useless. Whatever you're trying to get those people to consent to, they're not going to be, a court is not going to rule that they've consented to it. So don't pre-check things ever, never. Now, this also raises a secondary point where there's a lot of confusion. And so I'm hoping that I can clarify it for you here. EU cookie law. Yeah, I see this term used quite a bit, and it's just everything is a mess. It's completely wrong. First of all, there is no EU cookie law. Okay. There is a directive in the EU that deals with cookies, but a directive is not a binding law in the member states. The way it works is that the EU will pass a directive and it will contain certain, let's call them themes. Each member state then has to go out and pass their own legislation incorporating those themes. And that's what we have in Europe. But the member states can pass legislation that is very different from its fellow countries. So, for instance, in Finland, there is a method for obtaining consent, cookie consent, if we will, at the browser level, meaning that if a participant or an individual has gone to, let's say, Google Chrome, and they have set up how they want their cookies to work, well, as long as you can communicate with Google Chrome and get that information, you don't need a cookie pop-up on your site. Now, before you get excited about this, almost every other member state requires that you actually have the cookie pop-up. And so, it creates confusion. Directives are not great. Now it's been updated a couple times, but that's still kind of what you have out there, and you get into these issues of consent. Now, in May 2018, we started seeing cookie pop-ups everywhere. And the reason for that was that the GDPR was enacted on May 25th, 2018. It went into effect. And so all these pop-ups started appearing, and this was a result of lawyers such as myself trying to figure out how to address cookies. And it was a difficult situation because the GDPR is not a cookie law. It was never intended to address cookies. The word cookie is never mentioned in the GDPR, and even tracking information about tracking technology and things of this sort really isn't mentioned in the GDPR. And the reason for that is there was going to be a second regulation that came out called the e-privacy regulation. And that regulation was going to address cookies. It was going to set forth the requirements for cookie compliance and things of that sort. And it would have been much better than what we have today. So, for instance, it would have probably, we never had a vote, so we don't know what it was said, but the general idea was that, for instance, you wouldn't need a cookie notice, pop-up notice for first-party cookies. So if you're using cookies to help people just log into your site again without having to go through the whole login process, or to return to see things that they were looking at before on your site, any kind of first-party cookie, you didn't need all of these pop-ups and notices and things of that sort. And then there was going to be questions about, how would you go about getting consent in a way that was less obtrusive than it is today? And because it was a regulation, it would have been binding immediately, much as the GDPR was, meaning that states or member states would not have to pass their own legislation, and you wouldn't have different rules depending on which member state you were looking at. You would have one set of rules. That's the difference between a regulation and a directive in the EU. The EU is the directive is kind of a set of themes that member states go out and pass legislation on. A regulation is the law. It's binding immediately, much as the GDPR was. Unfortunately, since the e-privacy regulation never came into being, we end up with this tortured, and it is tortured, logic as to how the GDPR controls cookies. And the reason that you see all the cookie notices is lawyers start sitting around and thinking about the fact that, okay, well, under the GDPR, even though it doesn't talk about cookies, it does say we need consent, or we need a lawful basis for the collection of personal information, and there are a number of different types. Well, cookies are collecting personal information. Now, under the e-privacy regulation, we would have had a clear rule saying, okay, well, this is how you're going to deal with it. We don't have any of that under the GDPR. So instead, we're left with the idea of, well, we need some kind of lawful basis, and consent is probably the best way to do it. And that's why you see all these pop-ups everywhere with the, please consent to this, please consent to this. If you click this button saying, I accept, now it's all a huge fallacy. It's the unicorn of compliance approaches, because again, we're talking about an effort to comply with a law on the subject of cookies that the law was never meant to address. And it's a catastrophe. I mean, if you, depending on where you are, if you're in the United States, you probably see cookie pop-ups on maybe half the sites now. If you are in Europe, they are literally on every site. I mean, we're reaching the point where if you try to access a site in Europe from Europe, soon it's just going to be all pop-ups, and you'll have to click through like 20 of them just to get to the site. It's ludicrous because you have pop-ups coming with the new copyright directive over there and all these other things. So it's a mess. Now, the good news is that even the EU bureaucrats who, well, let's just say I don't give them much credit, even they have realized this. And the e-privacy regulation is now back on the docket. And there are being efforts to draft it now and to put together a version that everybody can agree on, which of course is extremely difficult. One of the early versions of the new privacy regulation would have moved consent up to the browser level, like we see with Finland, and that would have made life great because the cookie pop-ups that we see on all these sites, not all of them, but most of them would be gone. Why is that important? Because nobody's reading them. I'm a lawyer. I don't read them. You have something called cookie fatigue, which is if you have this stupid warning popping up on every site you go to, well, after a while, you don't read it. You just, all you're looking for is where's the stupid accept button. Click, 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 get this thing off my screen. I want to see the cat play piano. Whatever it may be. in the latest versions of the e-privacy regulation, they seem to have kind of moved away from that, but they're sort of back to where we are now. However, in the e-privacy regulation, even the recitals, it even talks about the fact we can't continue with this approach because of cookie fatigue. Nobody's reading the things. It's not, it's not accomplishing what it was supposed to accomplish. So I suspect we'll move away from that. What the ultimate solution is, I don't know. But the important thing to understand is if you're sick of cookie pop-ups and you're sick of dealing with them on your site, the good news is a solution is coming. I don't know what it will be, but at least hopefully we'll have one set of rules and everybody can comply with that. And even though you're probably not going to write your own software or anything of that sort, the third parties who are creating cookie compliant software will probably come up with a solution pretty quick. And hopefully my personal prayer is they do it at the browser level. I get a feeling they're probably not. But whatever they come up with, hopefully it's a lot less, obscene than what we have now. So anyways, out of this video, what should you take as a lesson? Going back to the, the checked box approach. Whenever you're using that, whether it's for cookie notices or it's for terms and conditions or pretty much anything, never, ever, ever pre-check the box. If you pre-check it, you might as well not even have it because it has no legal basis, no legal power to bind the people that you are asking to agree to something. So with that in mind, that is it for today's video. If you have any questions or comments, feel free to post them below. If you enjoyed the video, consider giving me a thumbs up. If you didn't, I feel shame. Give me a thumbs down. Feel free to subscribe to the channel. We'll be covering all kinds of privacy law topics, ranging from the GDPR, the privacy regulation, to the California Consumer Privacy Act, and beyond. Otherwise, thanks for watching. Have yourself a good one.